Conversation with Marshall Chriswell. We call it Martial Law, and this program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And one of those is the guy on the other end of the phone with me this morning, Marshall Chriswell. Good morning.
Good morning, Todd. Happy New Year.
And Happy New Year to you, too. All right, let's get rolling here. This morning, I don't think we've ever tackled this topic before, this subject matter. Let's talk a little bit about ethics, specifically an attorney's ethical obligations. They are very, very important, aren't they?
They are, yeah. But believe it or not, it may come as a surprise to some of the listeners, but attorneys have ethics rules that we've got to follow. And for the most part, we do a good job of following them.
Well, I know that there are tons and tons of jokes out there, but it is a very serious subject. And we need to be able to trust that our attorney is working in our best interests, and that's where it all starts.
That's right. Yeah, as a law student, you're required to. They start this training early. You're required to take classes on what they call professional responsibility, ethics, and we're required to do continuing legal education on ethics and ethics rules all throughout our careers, and so it's something that attorneys are very attuned to, and one of the biggest ethical issues, ethical pitfalls for attorneys, something you've really got to watch out for, are what's called conflicts of interest.
Yeah, and conflict of interest is something we hear a lot about in terms of criminal law, but it really is across the board for lawyers, isn't it?
Well, yeah. You could be a trial attorney working in a litigation setting, transactional attorney doing business transactions, or even residential real estate deal. Estate planning issues, conflicts come up, family law, divorce and child custody, those kinds of issues. There are potential conflicts there. So really across the board, for any type of matter that a lawyer is working on, you've got to be cognizant of potential conflicts of interest and deal with them as they come up. And dealing with them doesn't always mean, okay, I can't do this, but you've got to do it in an ethical way.
Is it always going to be the attorney that we hire who is going to alert us to possible conflicts of interest that attorney happens to be involved in and therefore must recuse himself or herself?
Well, generally the attorney will identify the potential or actual conflict that exists, but not always. Sometimes an attorney on the other side of the matter or otherwise involved, or even the judge in a case will raise the issue and say, okay, look, is there a potential conflict here because, the one attorney in this case represented somebody related to this matter in a previous case or setting, and so different players can raise those issues, but it is the responsibility of the lawyer taking on a matter to identify conflicts of interest, whether they're present at the outset or they arise during the course of the representation.
All right. Well, let's talk about what a conflict of interest might happen to be. Is it always going to be something like, I played for this team before, therefore I shouldn't be going up against them today, or is it some other aspect? What is conflict of interest really?
Yeah, so a conflict of interest is generally anything that substantially interferes with the duty of a lawyer to zealously represent a client. Okay, and so that can come in all sorts of forms, right? And as you mentioned, a common conflict of interest is where someone comes to me to represent them in a particular case, and I look at this, and we always do. Attorneys always do what's called a conflict check. Whenever you get a new client, you've got to do a conflict check and make sure, okay, have I represented this person? Have I represented somebody else involved in this litigation previously? Was the opposing party party, a prior client of mine, and you've got to check those things out. So yeah, that's one common one, right? If I say, well, you want to sue Joe Smith, but I represented him on a substantially similar matter, or I have a long-time representation relationship with him, I'm going to have to turn that down because it's conflict. But there are lots of other types of conflicts, right? Mm-hmm. So two clients come to you and say, well, we're friends or we're relatives, and we want to transfer some real estate, whether it's a sale or a gift, and we want you to do the paperwork. Okay, well, it's possible I can do that, but I do have to recognize that the two of them, being on opposite sides of a transaction, no matter how much they're rowing in the same direction, have a potential conflict of interest there that we have to deal with. And lots of conflicts do not rise to the level that you've got to withdraw. Often it does. But, sometimes I would say, well, one of you needs to go find your own attorney. But there are conflicts that are waivable. If they waive the conflict in writing, you can proceed. And often clients want you to do that because of expediency and convenience and efficiency.
Mm-hmm. Yeah, inside information is a key thing there, isn't it?
It is. And so that's really what you're looking at. You talk about these conflicts where you've represented someone previously, and I can't take on this new client. Well, you've got to look at, did I obtain information during that prior representation that would interfere with my duty even to that previous client? Not just necessarily to the client that just walked through the door. You have an ongoing duty to previous clients as well.
Yeah. In a small county such as Indiana County, and there are counties in Pennsylvania that are even smaller than ours, much smaller than ours.
Sure.
I would assume that conflict of interest is something that really must be paid special attention to because everybody knows everybody.
Well, you're absolutely right. In a smaller community where most attorneys like myself are general practitioners or involved in multiple areas of law, you get to know everybody, right? And so you really have to pay special attention to these conflicts and determining, okay, I think a lot of times people think about conflicts of interest in a colloquial sense, like, well, this attorney knows the one of the parties or had a professional relationship with them at one time or something. A lot of times those don't actually rise to the level of conflict, of a conflict of interest. You have to really be attuned to what the rules are specifically and identify those conflicts. Because just because I know somebody or I worked with somebody or my wife knows them or whatever the case may be, that doesn't necessarily make it a conflict of interest for me to be in a case on the opposite side of them. It's only where I've my relationship with them creates, like I said, it substantially interferes with my duty to represent this current client.
Conflict of interest is certainly one of, if not the biggest of the ethical concerns, but there are other ethics concerns, I would assume, for attorneys. What are some of those?
Well, there are all kinds of ethical rules, and there are the model rules of professional responsibility. Go through those, but if you've got to look at all sorts of things. If I'm a lawyer and I've got a family member who's also a lawyer, can I be on the opposite side of a case with them? And that's a consideration. Clearly, if I've got a relationship, professional or personal, with a judge, that creates issues. Ethical responsibilities arise. Confidentiality is a huge ethical issue that really, it's been said that confidentiality is the bedrock of the attorney-client relationship. And if you look at the ethical rules, confidentiality is a vein that runs straight through just about all of them. You have got to keep client confidences There are things that clients tell you that are confidential. Really anything regarding a representation of someone is confidential unless they have given you permission, or it's implied that you have permission to share those things for the good of their case. So confidentiality is extremely important. You run into issues with confidentiality. Even issues like, a lot of times somebody will come in, and happens a lot in child custody cases, that their parent, right? You've got a young mother or father who is concerned for child custody, and they come to you and they say, "Well, I want to proceed with a child custody case," and their parent is there and says, "Well, yeah, I want to help Johnny out here, and I'm going to pay for for your attorney's fees and the costs and everything, but I want to be involved in every decision." Mm-hmm. Well, I can't do that. You can't sit in every meeting, and because you're not my client, whether you're footing the bill or not, there are things that I have to be able to discuss confidentially with your son or daughter, and you can't direct the course of this litigation. You can write the check, though.
Yeah. And I would assume that much of this has to do with attorney-client privilege as well, which seems to have taken a hit in courtrooms over the course of the last year. That may just be me on the outside looking in, but it seems like that's sometimes viewed kind of shakily by some judges.
Attorney-client privilege. Attorney-client privilege is again, it goes hand in hand with confidentiality, where there are confidential issues that are discussed between attorney and client, whether it's discussed verbally, in email, in writing, however the correspondence may be, those things cannot be disclosed by the lawyer without the permission of the client, and the client is the only one who can waive the attorney-client privilege. There are some exceptions. If my client tells me that he's going to blow up a building, there is a public interest exception, right? I can go to the police, even though that's a confidential communication between the client and me. There are exceptions, but 99% of all client communications are protected by the privilege, and only the client can waive them.
All right. He is Marshall Chriswell, attorney, and if you would like his services, and obviously you would be quite interested in his ethical standards, and he upholds them highly, what would folks need to do, Marshall?
You can call my office, 724-465-5826. Stop and see us in the old R&P Coal Building, 655 Church Street in Indiana, or go online, check us out at www.westernpalawyer.com.
Very good. Thank you, Marshall.
Hey, thank you so much. Take care.